Hi guys, I hope you all are doing great. So we are going to start with our paper Corporate and Other Laws. So this is your paper 2 and this subject is divided into corporate laws and other laws. Like you can see, corporate laws is for 60 marks and other laws for 40 marks. Now corporate laws basically are those laws which are applicable to company form of organization. There are various acts which are applicable to companies, but in our syllabus we have only and only Companies Act. Okay. Under other laws, we have Contract Act, Negotiable Instruments Act, General Clauses Act, and Interpretation of Statutes. Now, before we actually go into the subject, I just want to give you a brief of what we are going to see under these acts. Now, Companies Act, you have had this in foundation as well. You have had very basics like what are the different types of companies, what do you mean by memorandum, what are the different clauses, what is articles, and certain doctrines, right? Now what we are going to see is the other sections of Companies Act, including what you have already had in CA Foundation. Okay, Companies Act has got totally 470 sections, out of which what we have in our CA intermediate syllabus is section 1 to section 148. Okay. Now, Indian Contract Act also you have had in your CA foundation. What you have seen in foundation is section 1 to 75, the basic, the general principles of contract. Okay. But what we have right now is section 123 to section 238, the balance part of Contract Act, that is the special contracts. Okay, when we start or when we get into this act, I will talk more about this. Now, Negotiable Instruments Act deals with the different types of negotiable instruments like bill of exchange, your promissory note, check, etc. So basically this act tells us what it means by a negotiable instrument, what are the different types of negotiable instruments, what are the characteristics of negotiable instruments, how do you actually negotiate a negotiable instrument, what are the rights, what are the obligations of parties, etc. Okay. Then the General Clauses Act. So there are certain very important definitions that are used in various different acts. What are those definitions? All of these we are going to see in General Clauses Act. Okay, there are many other things that we are going to see in this act, but I will talk about this when we come over there. Okay, and the last, like you can see, interpretation of statutes. Now if you see Contract Act, Negotiable Instrument, General Clauses, these are all particular acts, but interpretation of statute, this is not an act, because this tells us how we can actually interpret a law. How are we supposed to apply rules so that we can interpret the act and we can understand the act in the right sense. Okay, so this basically consists of various rules which will help us to interpret a statute. Fine. So this is what your syllabus is. Okay. Now about your exam pattern, your paper is 70 marks subjective and 30 marks objective. The best part about the objective type is there is no negative marking. The objective paper that you have, you can get them as separate MCQs, you can get them as 1 marker or 2 marker MCQs, or you can get a comprehension and then you will have many other MCQs. Okay. The subjective paper that you have, this paper is divided into 1 compulsory question, and then out of 4 questions you have to attempt 3 questions. Okay. So the compulsory question that you have is for 19 marks, and the other questions that you have, 3 out of 4 questions, they are for 17 marks each. Okay. So this way total you have to attempt 4 questions, and this is for 70 marks. Is this okay? Now in detail about your question paper also we are going to talk, but not right now. You know, we have just started. You exactly do not know what are the units or the chapters that we have in these particular acts or anything. So thoda syllabus hone ke baad I will cover all of this once again. Okay. Do you want to write this down? There's nothing to write over here. But maybe this you can just write this down, that how your exam paper pattern is going to be 70 marks subjective and 30 marks objective. Okay, and then your subjective paper pattern is like this. First question is a compulsory question of 19 marks. And then you have 3 out of 4 questions that you have to write. Okay, so what is expected out of you? Now you are expected to know the provisions of law. So see guys, you have written foundation, so you know already how your paper is going to be, how it is to how it is to write theory questions. But again, I'll tell you that you are expected to know not only the provisions of the act, but you are also expected to know the applicability of these provisions. Okay, so your ability to address the applicability oriented issues is also tested. So do you have to remember the provisions? Yes, you have to. Do you have to know when to apply which provisions? Yes, you have to. Okay, now I believe a lot in revision. We are going to revise quickly and many number of times. First, what we are going to do is focus on the concepts, understand the concepts very well. But if you understand it well and you're not able to write the same thing in the exam, are you going to get marks? No. So you have to remember these as well, correct? So not only is your understanding tested, but your memory is tested as well. Now I cannot, frankly, by heart anything as such. So I tell my students that instead of by hearting, it is better that you reread it again and again and again. Automatically तुमको याद हो जाएगा. Okay, you are not going to face any problem at all. Is this okay? Now what am I going to start with is, we will first cover Indian Contract Act, then we will do Negotiable Instruments Act, then we will do Companies Act, and then do General Clauses and Interpretation. I'm going to give you a lot of examples. We are going to discuss a lot of cases in Contract Act, Negotiable and Companies Act as well. Now I'll say most of these cases, or how did we interpret those cases, I am going to explain it to you in the later part, that is when we do General Clauses and Interpretation. So those two acts, General Clauses and Interpretation, are going to be super duper easy for you. Okay? Okay. So let us start with Contract Act. Now before starting, what we have in CA Intermediate, like I told you, you have sections in your foundation. You had section 1 to 75. Okay, right now what we have is section 123 to 1 to 238. So what about the sections over here? ये बीच के sections को क्या हो गया? Now these sections are nothing but they were relating to sale of goods, and when in the year 1930 a need was felt to have a separate act for sale of goods, they were removed from here and another act, Sale of Goods Act 1930, was made. Okay, so it means that whatever you have seen in foundation and whatever now you're going to see in intermediate is the complete Contract Act. Okay, now what is Contract Act? Contract Act deals with law of contract. Okay, now Contract Act, or law of contract as we say, is nothing but what you have promised has to be fulfilled, correct? What one party has promised the other party, that has to be fulfilled. So what is the object of Contract Act? Contract Act introduces certainty and definiteness in business transactions. You have seen this in detail in foundation. This is just a quick brief for you. I hope you are able to recollect what you have seen in foundation. So Contract Act, what is the object of Contract Act? To introduce certainty and definiteness in business transactions. What do you mean by certainty and definiteness? Now take the example of a factory owner. This factory owner enters into a contract with a coal supplier to supply. The coal supplier should be supplying, say, 100 tons of coal. Okay, the price decided, say for example, is 1000 rupees per ton. Okay? Now they enter into a contract that on 20th June the coal supplier is going to supply 100 tons of coal to the factory owner. Okay, the factory owner tells the coal supplier, see, I have a lot of laborers sitting idle in my factory. So agar ye coal nahi aata hai, so they will be sitting idle. I don't want them to sit idle. I want them to do the work. So please make sure that on 20th June you supply this coal. Coal supplier says, yes, absolutely no problem at all. Okay. Now on 20th June, two things can happen. What are the two things? The coal supplier supplies the coal, or the coal supplier does not supply the coal. So if the coal supplier supplies the coal, then well and good, because that is what the factory owner wanted. But if he doesn't supply the coal, do you think factory owner is just going to keep quiet? No. He will go to the market and make an emergency purchase. Now when he makes an emergency purchase, do you think the price is going to be 1000 or it is going to be lower or higher? Definitely it is going to be higher. So say for example, the factory owner ends up spending 1500 rupees per ton. Okay. Now if the coal supplier had performed the contract, factory owner would have spent only rupees 1000. But since this contract was not performed, factory owner is spending how much more now? He is spending 500 rupees more. So this extra that the coal factory owner has spent, he can claim this from the coal supplier, and this will be called as what? Very good. This will be called as damages. Right? Correct? So what is this ensuring, or what do you see, or how is the Contract Act important over here? Is Contract Act is introducing certainty or definiteness. The factory owner is certain that on 20th June coal supplier will supply coal. If he doesn't supply coal, factory owner is certain that in case the factory owner ends up spending more amount, he can recover those damages from the coal supplier. Okay, so Contract Act basically ensures that what you have promised has to be fulfilled. जो वादा किया वो निभाना पड़ेगा. This is what is Contract Act ensuring. Correct? Okay. What do you mean by contract? We've seen this. Now tell me, what do you mean by contract? Contract is equal to, yes, ये अच्छे से याद है सबको, agreement plus enforceability by law. Contract is equal to agreement plus enforceability by law. What do you mean by agreement? Agreement is nothing but offer plus acceptance. What do you mean by offer? When one party expresses his willingness to do or not to do something, it is said that he is making an offer. When the other party accepts this offer, it is nothing but acceptance, right? So what do you mean by proposal? Have you heard of this word as well? Yes, offer and proposal. These words are one and the same. Okay. Now accepted proposal is nothing but a promise, and a promise is nothing but an agreement. Okay, so agreement is nothing but a promise, promise is nothing but an accepted proposal, and proposal is nothing but when a party signifies his willingness to do or not to do something with the intention to receive the assent of the other party, it is said that he is making a proposal. The act uses the word proposal, but proposal and offer are absolutely one and the same. Okay? Now, what do you mean by enforceability? Enforceability means legal obligation. Enforceability means legal obligation. Means what? Whenever you take this particular case to the court has to accept the case. Means the court should be ready to give a decision on the case. And how will court give a decision? Is court will see that either it helps the party to obtain performance or to obtain compensation. Okay, so court will see that the party either obtains the performance or obtains compensation. Fine. Is this clear? So this is what it means by contract, correct? I know you have seen this very much in detail in foundation. This was just a quick recollection for you. Now instead of writing like this, I will write it in another way so that you can copy it as well. So agreement is nothing but a promise. Promise is nothing but an accepted proposal. Accepted proposal is nothing but offer plus acceptance. Okay? And enforceability by law means legal obligation. It means court should take this case. Court will help the parties to obtain performance or to obtain compensation. Okay, write this super quickly. Contract is equal to agreement plus enforceability by law. Agreement is nothing but a promise. Promise is nothing but accepted proposal. Accepted proposal is nothing but offer plus acceptance. Enforceability by law means legal obligation. Legal obligation, court will help the parties to obtain performance or to obtain compensation. Okay, so certain more terms that we have already discussed in foundation, but let us just quickly see what they are over here. So proposal or offer, we spoke about this just now. So when one person signifies to another his willingness to do or abstain from doing anything with a view to obtain the assent of that other to such an act or abstinence, he is said to make a proposal. Then promise. Promise, when a person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So a proposal when accepted becomes a promise. Then agreement. Every promise and set of promises forming consideration for each other is an agreement. Thus in other words, it means that in an agreement there must be proposal or offer by one party and its acceptance by the other. Right? So agreement is nothing but offer plus acceptance. Contract. Contract means an agreement which is enforceable by law is a contract. Correct? Okay. Then void agreement, void contract, voidable contract. Now before we see this, let us see first what does it mean by a valid contract. What do you mean by a valid contract? Contract that is valid, don't tell me this. Valid contract means that contract which satisfies all the essentials of a valid contract. How many essentials are there? There are 9 essentials. What are they? There has to be offer and acceptance. The parties should intend to create legal obligation. There has to be lawful consideration. Parties should be competent to enter into contract. The consent of the parties should be free and genuine consent. The object of the contract must not be unlawful. The agreement should not be expressly declared as void. It should be certain and possible to perform the agreement, and the legal formalities have to be completed. Yes, I'm sure you're able to recollect all of this. Quickly, let us see what are each of these points. There has to be an offer and acceptance. So we know that for an agreement to be formed, agreement is nothing but offer plus acceptance. So a contract can be formed first of all only if there is an agreement. So where one party gives an offer and the other party accepts the offer, an agreement is formed. When this agreement is enforceable by law, it is a contract. Correct? Then the parties must have an intention to create legal relation. So whenever parties are entering into a contract, they should intend to create legal obligation. Now husband tells wife that I will take you out on a candlelight dinner on Saturday at 8 o'clock. Wife is ready, waiting for the husband to come home. Husband does not come home at all that night. Now wife is so angry. Wife tells, candlelight dinner पे नहीं आए, चलो कोर्ट में आ जाओ. Wife wants to file a suit on the husband. Is this suit sustainable? Answer is no. Why is it not sustainable? Because the parties did not intend to create legal obligation. Now, how will you know whether the parties intended to create legal obligation or not? It is dependent upon a presumption. In case of business transactions, there is a presumption that the parties intended to create legal obligation. And in case of other transactions, there is no such presumption. This presumption is also rebuttable. What do you mean by rebuttable? It means proving otherwise. So where a husband and wife are entering into a contract and they can prove that they intended to create legal relation, then this will be a valid contract. Okay? Then the parties must be competent to contract. So incompetency of the parties is when a party is a minor or of an unsound mind, or he is disqualified by law. So to be competent to enter into contract, he should be a major, he should be of a sound mind, and he should be not disqualified by law, right? So convicts, alien enemies, foreign sovereigns, insolvents, I hope you remember all of this. Okay. Then there has to be lawful consideration. So consideration means something in return. If there is no consideration, then there is no contract. But of course, in certain cases, in case you have exceptions where even though there is no consideration, the contract is valid, right? Then the parties, the consent of the parties should be free and genuine. So when do we say that the consent is not free? When it is caused by coercion, undue influence, fraud, misrepresentation or mistake. So the consent of the parties should be given voluntarily by the parties themselves. It should not be obtained by coercion, undue influence, fraud, misrepresentation or mistake. Correct? Then the object of the agreement must be lawful. So when the purpose for which you are entering into a contract should not be legal, or it should not be immoral, or it should not be opposed to public policy. Okay? Then the agreement is not expressly declared to be void. So Contract Act gives a list of certain agreements which are expressly declared void. So for example, entering into contract with alien enemy, marriage, agreements in restraint of marriage, these are expressly declared to be void. So even if you satisfy all the essentials of a valid contract, still your contract is not going to be valid because it falls under this list. Okay, then it should be certain and possible to perform the agreement. So if you enter into a contract, A tells B that he will get Chand Tare for B. Is this a valid contract? No. Why? Because it is not certain. It is not possible to perform this contract. Okay. Now I want to sell my phone for 40,000 or for 50,000. Is this a valid contract? No, because it is not certain. So your contract should not only be certain, but it should also be capable of performance, possible to perform. Okay. And last formality, the last essential, the legal formalities for entering into such contracts are completed. So can contracts be oral? Yes. Should contracts only and only be in writing? Need not be. But when should they be in writing? If law specifically mentions so. So for example, all government contracts or all arbitration contracts compulsorily have to be in writing only. So, or another example, maybe purchase of land. So this contract has to be made in writing only. So if you make an oral agreement, oral contract for purchase of land, is it going to be valid? Then it will not be valid, because even though Contract Act is not specifying certain things, but if any other act specifies it, then that act also should be followed. Is this okay? So these are the essentials of a valid contract. Okay. So what do you mean by a valid contract? Valid contract means that which satisfies all of these 9 essential elements. Now again, in detail, you have seen it in foundation. You are not going to get a question right now in CA intermediate where they are going to ask you state the essentials of a valid contract. But you should know what this is, because going ahead in Contract Act, I am going to link maybe a few points here and there. Okay, I am going to ask you questions and you should be able to answer that. So for that, you should know what these are. Okay, then void agreement. So this is another if a contract is not a valid contract, then it can either be a void agreement, or it can be void contract, or it can also be a voidable contract. Correct? What do you mean by void agreement? Void agreement is that agreement which is not enforceable by law. From the time it is made, it is void. So from the initial stage itself, it is void. So this is called as, it is void ab initio. Example, agreement with a minor. From the time you enter into contract with a minor, it is a void agreement. Correct? Another example. Now you want license, a 2-wheeler, 4-wheeler license. You find some agent and that guy tells you that, you know, you give me 5,000 rupees. There is no need for you to go and give the test. You will get your license at home. Now say for example, you give him 5,000 rupees. Okay. Now if suppose he doesn't give the license to you, can you recover this 5,000 rupees from him? You cannot recover this 5,000 from him. Why? Because entering into such a contract with that person is a void agreement. It is opposed to public policy. It is it does not have any validity at all. Okay? In case of void agreement, restitution of benefit is not allowed. What do you mean by restitution? Restitution means restoring a benefit already obtained. So when this agent has received the 5,000 rupees, he is not bound to give that 5,000 back to you, because he can keep that benefit that he has obtained. Okay? So void agreement is that agreement which is not enforceable by law, which is void ab initio and in which restitution is not allowed. Okay, so any agreement which is opposed to public policy or bribery kinds of agreements, agreement with a minor, agreement without consideration, all of these are void agreements. Fine, let us read this quickly. An agreement not enforceable by law. Agreement not enforceable by law is said to be void. A void agreement does not create any legal rights or obligations. It is void ab initio. That is from the very beginning. For example, an agreement with a minor or an agreement without consideration and restitution of benefit is not allowed in case of a void agreement. Is it okay? So restitution means restoring a benefit already obtained. In case of void agreement, restitution is not allowed. Clear? Okay. Then we have void contract. Void contract is that contract which when you enter it is valid, but later on it becomes void. So it is valid at the time of entering into, but subsequently it becomes void. For example, a person in India wants to export 100 kgs of onions to a person in Dubai. Can he do that? Yes, absolutely, no problem at all, right? Out of this 100 kgs, say 60 kgs of onions he has already exported. And then in India, law changes. Export of onions is banned. Now can he export onions to this person in Dubai? He cannot, correct? So now, so when he entered into a contract, was it a valid contract? Yes. But now what has happened? It has become void, correct? Now, if suppose this person for the importer in Dubai, if he has paid an advance for these 40 kgs of onions, then that advance, what should this person in India do? This seller, he will have to return that advance back, correct? 60 kgs के लिए जो contract perform हो चुका है, for that the payment is valid, he will receive it. But I'm talking about the balance 40 kgs which he couldn't give. Why couldn't he give that? Because law had changed in India. Export of onions was now banned, correct? So for this 40 kgs, if any advance the importer has received, the exporter has received, he will have to return it back, correct? So over here, restitution is allowed or not allowed? You tell me. Restitution is allowed. Restore a benefit that you have obtained. For the 40 kgs which was not yet performed, this Indian had received the advance, but since the contract is not performed now, restore that to the importer, to the person in Dubai. Is it okay? So see, void contract. A contract which ceases to be enforceable becomes void when it ceases to be enforceable. A contract when originally entered into may be valid and binding on the parties. Example, a contract to import goods from a foreign country. It may subsequently become void. That is when a war breaks out between the importing country and the exporting country, and restitution of benefit is allowed. Is this okay? Is this clear? Okay. Fine. Just write down export of onions. There's no need to write anything as such. You already know this. You just have to recollect it at the moment. So export of onions. Okay. Then voidable contract. What is a voidable contract? Voidable contract is that which is enforceable at the option of one party but not at the option of the other party. Now listen. Mr. A has got a beautiful house worth rupees 5 crores. Okay. One gunda, Mr. G, at gunpoint tells Mr. A, you transfer this 5 crores house to me for 5 lakh rupees. Otherwise, I will kill you. Okay, so what is Gunda doing? Absolutely right, coercion. So Gunda is telling A to transfer the house for 5 lakh. Now A thinks, oh my god, I have a wife and kids at home. Itna, who is going to take care of them if I die? So what A does? Immediately transfers the house to G. Fine. For how much did he transfer? 5 crores house. He transferred it for 5 lakh rupees. Fine. That night, Mr. A could not sleep at all. So he thought that, if he doesn't go to court, what he's doing is absolutely wrong. Hai na? So it is better that he goes to the court because he does not want to encourage this kind of behavior. So what he does is he goes to the court. Now when he goes to the court, court asks him kya hua. He tells that, see, my house is worth 5 crore rupees. But why did I transfer it for 5 lakhs to him? Is because I was at gunpoint. Court will value the house and court will tell, yes, what you're telling is absolutely right. Now, because you do not want to go ahead with this contract, court will cancel the contract. When court cancels the contract, court will tell Gunda, return that house back to Mr. A. And court will tell Mr. A, return that 5 lakh rupees that you had received. Okay. So what is court doing basically? Restoring the benefit that is obtained by the parties, right? So in case of avoidable contract, restitution is allowed. Okay. Now this is one scenario. There can be another scenario. This Mr. A feels that, if the next day or after that, whenever he goes to the court, the Gunda will come again and Gunda can shoot him again, correct? So Mr. A feels that, leave it, let my house go off to Mr. Gunda. I will earn this money, I will buy another house. Right? But if I die, then kya hoga, correct? So what Mr. A does? Nothing. He does not go to court at all. So what happened to the contract now? The contract now remains valid. Okay? So basically, voidable contract is nothing but, in simple terms, voidable contract is nothing but avoidable contract. So if the aggrieved party wants, he can go to the court and cancel the contract. If he does not cancel the contract, then the contract will remain valid, right? So this Mr. A, aggrieved party, has got basically 2 options: to avoid that contract or to keep it valid. Another term for avoid is resigned the contract. Another term for resigned also is repudiate. Okay, all these mean the same thing. So Mr. A can avoid or resign the contract, or he can keep the contract valid. Now if he is avoiding or resigning the contract, he has to do it within a reasonable time or before rights of third party intervene. Now Mr. A, he transferred the house to Gunda. It's been 2 years since he transferred. Suddenly after 2 years he feels, no, I want to go to court to cancel the contract. He goes to the court to cancel the contract, but the house is not in Mr. G's name now. Mr. G has already transferred the house to Mr. X. Mr. X is a third party. If Mr. X's rights are involved, then court will not cancel the contract. So basically court is telling you, you have to act very, very, very fast. Okay. So if you want to avoid the contract, you can avoid it, provided it is within reasonable time and before rights of third party intervene. What do you mean by reasonable time? Reasonable time is when law cannot give you a fixed duration, law says reasonable time. Reasonable time varies for every case. So based on the circumstances of the case, you will have to determine what is reasonable time. Okay. If you have ordered for a book online, the books will get delivered maybe in 3 days, 4 days, maybe 1 week's time as well, correct? If you have ordered pizza should be delivered within 30 minutes, correct? If pizza is delivered after 4-5 days, is it reasonable? No. So how do you know what is reasonable time or not? It depends upon the facts and circumstances of that particular case. Is this okay? So this is about a voidable contract. Restitution in voidable contract is allowed. Very good. Okay, so see, an agreement which is enforceable by law at the option of one or more parties but not at the option of the others is a voidable contract. A voidable contract continues to be valid till it is avoided by the party entitled to do so. The party whose consent is not free may either rescind the contract if he so desires or elect to be bound by it. The aggrieved party must exercise his option of rejecting a contract within a reasonable time and before rights of third party intervene. Otherwise, the contract cannot be repudiated. Restitution of benefit is allowed. Is it okay? Yes, I know you guys know this really very well, but this was necessary for us to start with Contract Act. Okay? Start with our intermediate syllabus. I meant intermediate syllabus of Contract Act. Fine? Now, this act, Contract Act, is divided into two parts. The general principles of contract and special contracts. Now, how are general principles of contract different from other acts? General principles of contract provide the broad parameters of contracting. They provide the broad parameters of contracting. The rights and obligations of the parties are to be decided by the parties themselves. If I want to sell my house to a buyer, say, I want to sell it to a buyer, at what price I should sell it, by what date, how much money I want it, how much money in which bank account I want, how much money I want in cash, how much money I want in as online transfer, all of this is to be decided by the parties themselves, correct? है ना? Now, nowhere under general principles have you exactly seen rights of the promisor, duties of promisor, rights of promisee, duties of promisee. है ना? Do you remember seeing this in foundation? You didn't. But same thing if you talk about Sale of Goods Act or Partnership Act, you have seen over there rights of buyer, rights of seller, rights of partners. है ना? So general principles in this sense are very different from other acts wherein they only provide the broad parameters of contracting. Like they say, consideration has to be there. How much consideration? It depends on the parties. You can decide, right? The parties have to be competent to enter into contract and such other things are specified, correct? Special contracts of Contract Act are different from the general principles. There are 5 special contracts which Contract Act deals with. They are indemnity, guarantee, bailment, pledge and contract of agency. Over here you are going to see rights and duties of the parties who are involved in these particular contracts. Okay? So now let us start with contract of indemnity. This is first that we are going to do. Contract of indemnity. What do you mean by indemnity? Indemnifying. है ना? What do you mean by indemnifying? Simple terms. It means to compensate. Correct? It means to compensate. So basically over here you are telling that if you have a loss, I will compensate you for the loss that is caused to you. है ना? Indemnifying. I will compensate you for the loss that is caused to you. Okay? Now, in layman language, this is nothing but a contract of insurance. Right? What happens in a contract of insurance? Now say for example, Mr. A has insured his car. So Mr. A goes to an insurance company, say General Insurance Company, to get his car insured. His car is worth 5 lakh rupees. Say he takes an insurance for a coverage of 5 lakh rupees. Okay. Now what does he pay to General Insurance Company? 5 lakhs. He will not pay 5 lakhs. He will pay something called as insurance के लिए. He will pay something called as premium. Correct? And what is he getting in turn from the company? from the insurance company, he is getting a promise. The company says, in case your vehicle is damaged, then we will compensate you for the loss that is caused to you, right? So is this a valid contract? Yes, absolutely, it is a valid contract, right? Now, this contract of insurance, can I say is a contingent contract? Yes or no? Yes. What do you mean by contingent contract? Contingent contract is that contract, the happening or non-happening of which depends upon a contingency. So that collateral event may or may not happen. The main contract is dependent upon the happening or non-happening of that collateral event. So I have insured the goods in my factory. If there is a fire in my factory and the goods are damaged, then I am going to get compensation from the insurance company, correct? If my goods are not damaged, then will I get any compensation? I will not get a compensation. So on what basis is this compensation based? Compensation is based, correct, on the loss that is caused to the party, correct? Only and only if a loss is caused, this compensation will arise. If there is no loss that is caused, then the compensation will not arise, correct? Now, this Mr. A, who has taken the insurance from the insurance company, he is called as the indemnity holder. Indemnity holder. And this insurance company is called as indemnifier. Okay, indemnifier. I'm going to give you time to write. Please listen first and then we will copy this. Okay. Now this indemnity holder is also called as indemnified. Okay. So indemnity holder is the one to whom compensation is supposed to be given, or who is going to get the compensation. Indemnifier is that to who promises to compensate the other party. Okay, I have gifted my mom an iPad. She really loves that iPad. She clicks pics with that iPad only. She is going on a vacation with her friends, so I tell her, take that iPad with you. She says, no Baba, if something happens, if it gets damaged, then what? So I tell her, don't worry Mama, if there are any consequences, I will take care of it. Okay, she goes for a vacation and she comes back and कुछ खराब हो जाता है वो iPad में. Then we go to the store and we get it repaired. 5,000 is the cost of the repairs. I will compensate this 5,000 to my mom, give this 5,000 to my mom, correct? So two possibilities, either I directly pay for the expenses or my mom pays for the expenses and I will indemnify her, compensate her. Both mean one and the same thing, right? Now in this case, I am indemnifier. My mom is indemnified, indemnity holder. Is this okay? Did you understand this contract of insurance, indemnity? Okay. Now, let us see the definition of contract of indemnity. In terms of this section, a contract by which one party promises to save the other party from the loss that is caused to him by the conduct of the promisor himself or the conduct of any person is called as contract of indemnity. We will talk about this definition in detail again in a minute. Let us just see the next sentence first. Indemnity means to make good the loss incurred by another person, or to compensate the party who has suffered some loss, to protect the party from incurring a loss. Now all of these, they look one and the same. There is slight difference in these points. Now first of all, the most common point over here is there has to be a loss. Indemnity arises only and only when there is a loss caused to the other person. Correct? So when does the liability of the indemnifier arise? Listen to my question very carefully. When does the liability of indemnifier arise? When the loss of the indemnified becomes certain. When the loss of the indemnified becomes certain. So when should this insurance company pay money to Mr. A? When Mr. A's car is damaged, correct? So when will the company pay to Mr. A? When A's car is damaged means when does the liability of the indemnifier arise? When the loss of indemnified becomes certain. Is this sentence okay? So when does the liability of indemnifier arise? When the loss of indemnified becomes certain. Okay? Now see the meaning again of indemnity. To make good the loss incurred by another person, or to compensate the party who has suffered some loss. You are wearing a beautiful watch. I want to see your watch. So what I do, I take your watch. I'm playing with your watch. That watch falls down. Now when that watch falls down, the glass dial, it breaks. So if it breaks, then what? Obviously I have to get it repaired, correct? So what I do, I take it to the repair shop and he tells me the repairs is going to cost 2000 rupees. Fine. So I give 2000 rupees and I get it repaired. Or another scenario, you go to the shop, you find out 2000 rupees hai, you pay 2000, you get it repaired, and I compensate, I give this money to you, correct? Imagine another scenario. I'm playing with the watch falls, the watch breaks, and it is beyond repair. Kuch nahi ho sakta, it has to be thrown away now. So what am I supposed to do? I am supposed to get you a new watch, correct? So now see, there is a slight difference between getting a new watch and repairing that existing watch, right? So see the sentence over here. Making good the loss incurred by another person to compensate the party who has suffered some loss. Repairing that watch is nothing but compensating you for the loss that you have suffered. Getting a new watch altogether is nothing but making good the loss. Okay? In both the cases, I understand, in both the cases there is a compensation, there is a contract of indemnity. Yes, definitely, that is what we are studying. The slight difference between these two, making good the loss is getting a new one, compensating the party who has suffered some losses is paying for the repairs. Okay, so just write these words now. We will write again in a few minutes. Making good the loss is new watch, and compensating the party who has suffered the loss is paying for repairs. Okay. Now I have a Dell laptop. Okay. I love my Dell laptop. I love the company as well. Their after sales service, it is truly amazing. I have been using Dell laptop for over 10 years now. My first laptop was Dell, until now I have Dell only. Okay. Now let me tell you, this is not a paid promotion. I genuinely love the laptops. Now I want to give you a very nice example over here. I had purchased a laptop in around 2010. It was a nice model. I used it for a long period of time. Now with that company, first time when you purchase a laptop, you can take an insurance for 3 years, and after 3 years period you can extend it for 2 years. Okay. Now when I was using the laptop, after about I think 4 years of usage, it fell from no, actually what had happened is within the first 3 years my laptop fell down, and you know, I felt that keyboard या screen ऐसे कुछ तो problem है, So I called their service center and I told them my laptop has fallen down. It was covered under insurance. So they said that, ma'am, please send photos of what exactly has happened to your laptop. So I told them that I think only the keyboard is gone, but after seeing the photos they said no, not only the keyboard, there is some problem with the screen as well. So they came home, they repaired it, they replaced whatever parts they had to replace. Okay, now after another year or so, I extended the insurance for obvious reasons, and my laptop again fell down from a great height. Now when it fell down from a great height, the screen was completely broken, the keyboard was totally out. Keyboard के ऊपर एक ऐसे panel types था, that panel also had come out, and it was a nice heavy laptop, but it was all broken. Again I called the service center. They said, ma'am, again please you send photos and we will see what it is. So they saw the photos, then that technician came, they replaced whatever part they could. Now just above the keyboard was a small panel. It did not have any touch button or anything, it was just a normal panel. But when I shut the laptop was not getting properly closed. Thoda sa, there was a gap over there, because वो panel का कुछ तो भी थोड़ा सा बीच में आ रहा था. It was not coming in between the performance of the laptop as such, but it was a little inconvenient. So I called them again. I told them that, sir, you had replaced all of these parts, you had changed all of this, but now, my laptop still, I feel that it is not getting properly closed. Can you see if there is something wrong with the panel? So he checked and he said, ma'am, I'm so sorry. We have discontinued this laptop. This is an old model now. We have totally discontinued this laptop. So that part, that panel which is needed, we do not have it. We cannot give it to you. So I just thought to myself, okay, fine, I'll adjust with that. At that time he said that, ma'am, since you have taken this laptop for 55,000 rupees, we will give you an entire credit note for the entire 55,000. So with this 55,000, either you can purchase an all new laptop, or you can purchase 1 or 2, 3 laptops if it fits in this. Or if you want to purchase an expensive laptop, you can add your own money and you can purchase the laptop. So basically they were giving an entire replacement, totally a new laptop, right? So they were giving the money back, but I would like to put it as if they are giving me a new laptop, right? Now see how beautifully this contract of insurance has worked. Initially, they compensated me for the loss that was caused, correct? And later on, when that loss was not repairable, they also agreed to make good the loss by giving me a new laptop. Is this clear? So I hope this is totally and absolutely clear now. So contract of indemnity means either making good the loss or compensate the other party for the loss that is caused. But what is very important in a contract of indemnity, loss has to happen, because only when loss happens, the liability of the indemnifier arises. Okay, the parties in contract of insurance, in contract of indemnity, are who? Indemnified, indemnifier. Indemnified, also called as indemnity holder. Indemnifier is the one who is going to compensate. Indemnified is the one to whom compensation is to be received. Okay, now is this a contract of insurance, contract of indemnity? Yes. So when we tell contract, it means all the essential elements of a valid contract has to be satisfied. Okay, all the 9 essential elements have to be satisfied. So if suppose A agrees to, A tells B that you kill Mr. C and whatever are the consequences, I will indemnify you. Will this be a valid contract? No. Why? Because the purpose of the contract, the object is not a lawful object. Okay, so since this is also a contract, all the essentials of a valid contract have to be satisfied. Is it okay? Now there is something else that I want to discuss, but let us first write this down and then we will discuss it. So over here in this definition, this is the part that I am going to discuss now, but let us write this down first. Okay, so write this in your notebook. Mr. A has got a car. Mr. A has a car and he takes an insurance from General Insurance Company. He takes an insurance from general insurance company. Mr. A pays premium. Mr. A pays premium and in return gets a promise from the insurance company, and in return gets a promise from the insurance company that in case Mr. A's car is damaged, that in case Mr. A's car is damaged, the company will reimburse, will compensate, right? Compensate. The company will compensate Mr. A. Okay. Now tell me one thing. How much will insurance company compensate? जितना भी loss हुआ है, will they compensate? Like literally everything will they compensate? It depends upon the terms and conditions of the insurance contract. Okay. Now there are various insurance contract. Now you must have heard of something called as third party coverage. So third party coverage means when you take this insurance because of your vehicle, if any जो भी third party के vehicle को loss या damage हुआ है, that insurance company will bear, but they will not bear anything that is cost to your, that loss is cost to your vehicle. There is something called as comprehensive coverage, wherein they will cover the basic basic labor charges. They will not cover what the part replacement cost. There is something called as zero dep insurance or nil dep insurance. Over here, the entire loss damage cost to your vehicle will be borne by that insurance company. Matlab they will compensate you for that. So these are basically different types of insurances. What is covered, what is not covered, it depends upon that particular contract. Okay. So as of now, we are not talking about it. So we are just talking about normal insurance, maybe full coverage kind of insurance. So whatever loss is caused to Mr. A, the company is going to bear that loss. Okay. So write this. Mr. A is the indemnity holder, also called as indemnified. Mr. A is the indemnity holder, also called as indemnified, and the insurance company is the indemnifier. Insurance company is indemnifier. Okay, then write this. If Mr. A's car is damaged, if Mr. A's car is damaged and loss cost to Mr. A is for rupees 2 lakhs, loss cost to Mr. A is for rupees 2 lakhs, the insurance company will compensate A for 2 lakhs. The insurance company will compensate A for 2 lakhs. Then write, when does the liability of indemnifier arise? When does the liability of indemnifier arise? When? Answer is when the loss of indemnified becomes certain. When the loss of indemnified becomes certain. Okay, this is clear? Okay, you can write this sentence also. Contract of indemnity is a contingent contract. So contract of indemnity is a contingent contract. Fine. Now see, I have taken your watch. If I damage your watch, I have to compensate you, correct? If suppose you are using your own watch and your watch gets damaged, then will I compensate you for your watch? I will not compensate you for your watch, correct? Now let us take another example. If suppose you have insured your mobile phone, okay? I am using your mobile phone and I damage mobile phone. Will you receive the compensation for the damaged phone? Yes. You yourself are damaging the mobile phone. Will you receive compensation for that? Yes, you will. What about theft? If your mobile is stolen, will you receive compensation? Yes. What about, your mobile phone being lost or being damaged under a natural calamity? एक सुनामी आता है और तुम्हारा फोन खराब हो जाता है, कुछ फायर होता है, तुम्हारा फोन खराब हो जाता है, earthquake आता है and your phone is damaged. What about these acts? What about the loss that is caused to your belongings, to your asset because of an act of God? Yes, this term is a recognizable term. Act of God means natural calamity. What about it? Will your insurance company compensate? Yes or no? Yes or no? So if your car, you meet with an accident, if your car is stolen, if your car is damaged because of natural calamities, are you going to get compensation in all of these cases? Yes or no? Answer is, it depends upon the terms and conditions of your contract of insurance. If these terms are covered in your contract of insurance, then yes, you will receive this compensation. Okay? Why are we talking about this is because let us see the actual definition of indemnity once again. A contract by which one party promises to save the other from the loss caused to him by the conduct of the promisor himself or the conduct of any person is called as contract of indemnity. If you see over here, the damage that is caused should only be because of two reasons. It should either be conduct of the promisor or conduct of any other person. That's it. This definition does not talk about any act of God kind of a situation, right? So if in case you are getting a compensation because of the loss caused due to act of God, is it a contract of indemnity? This is my question. Are you understanding? If you're receiving a compensation because of the loss that is caused to you because of act of God, is it contract of indemnity? Answer is, even though this definition does not cover act of God, whenever you study a law, you not only read the particular act which is relating to that law, but you are also guided by judicial decisions. So cases which have happened before, court has given a judgment for that. If your case is similar to that case, then you can apply the same decision to your case as if it is given in the act itself, है ना? So judicial decisions are also applicable to you, correct? So as per one of the judicial decisions, act of God की वजह से जो reimbursement, जो compensation होता है, that also will be covered under contract of insurance. Okay, so can I say this definition of indemnity is an incomplete definition? Yes. Is it an exhaustive definition? मतलब जितना दिया हुआ है, that much only is valid. Is it that kind of definition? No, it is not an exhaustive definition. Is this okay? So the reason for loss can either be the conduct of promisor, or it can be conduct of any other person, or conduct of promisee, or it can also be an act of God. Is it okay? Is this clear? Simple. This point is written later. So now let us start reading this. Parties to the contract. There are two parties in this form of a contract. The party who promises to indemnify, that is to save the other party from the loss, is known as indemnifier, whereas the party who is promised to be saved against the loss is known as indemnified. Modes of contract of indemnity. So express contract of indemnity or implied contract of indemnity. Express contract, so where a person expressly promises to compensate the other from a loss. Insurance contract that you enter into is an express contract of indemnity. Implied contract, when a contract is to be inferred from the conduct of the parties or from the circumstances of the case. I have taken your phone to make a call and I damage your phone. Even though there is no implied contract, even though there is no express contract, I will have to compensate you for the loss that is caused to you. This is an implied contract. By my conduct, we have entered into this contract. Okay. Then, essential elements of a contract of indemnity. All the essentials of a valid contract also must be present in a contract of indemnity. We spoke about this. So, example, X asks Y to beat Z. X promises to indemnify Y against the consequences. Y beats Z and is fined 1,000. Y cannot claim this amount because the object of the agreement is unlawful. Okay. Then loss to one party. In a contract of indemnity, a person agrees to indemnify another person in case such other person incurs some loss or the loss of such other person becomes certain. This sentence also we have written. When does the liability of indemnifier arise? When the loss of indemnified becomes certain. Then indemnity by the promisor. The purpose of contract of indemnity is to protect the indemnity holder from any loss that may be caused to this indemnity holder. Reason for loss. So even though the definition talks about only conduct by promisor or any other person, but the reason for loss can be any reason. The contract of indemnity must specify that the indemnity holder shall be protected from the loss caused due to the conduct of the promisor himself or the conduct of any other person or any act, event or accident which is not in the control of the parties. So this also covers what? Act of God. Is it okay? So reason for loss can be conduct of promisor himself, conduct of any other person or any act, event or accident which is not in the control of the parties. Is this okay? Is this very simple? Yes, totally simple. Okay, so contract of indemnity has got two parties. They are indemnifier and indemnified. Indemnity holder is also indemnified. Is this also a contract? Yes. So all the essential elements of a valid contract have to be satisfied. Correct? Reason for the loss can be any loss, conduct of promisor or any other person or any act or event which is not in control of the parties. Okay? Now I have one question to you. Life insurance contract. Is this a contract of indemnity? Life insurance contract. Is this a contract of indemnity? Life insurance contract, what happens in this? Now Mr. A, he'll pay a premium for whatever the policy is. Say for example, he pays a premium for 10 years. And whenever he dies, he is going to get a fixed compensation. Hai na? Say for example, that compensation is 20 lakh rupees. So when Mr. A dies, the insurance company is going to give his family 20 lakh rupees. Correct? Is this a contract of indemnity? Answer is no. Life insurance is not a contract of indemnity. Now when 20 lakh rupees is given to the family, does it mean that Mr. X ka value, Mr. A ka value was 20 lakhs, Mr. A's worth was 20 lakhs? Does it mean that? No. Can the insurance company say, Mr. A nahi hai na, take this, another Mr. B in place of Mr. A? Possible? Not possible, right? So you cannot, as such, in case of life insurance, you cannot compensate for the loss cost, or you cannot make good the loss as such. Correct? So that is why contract of insurance, life insurance is not a contract of indemnity. Then what is it? It is a contingent contract. So in case of death of A, his family members are going to receive 20 lakh rupees. It is a contingent contract, but it is not a contract of indemnity. Okay? So write this sentence down as well in your notebook. Life insurance contract. Life insurance contract is not a contract of indemnity. Life insurance contract is not a contract of indemnity. It is a contingent contract. It is a contingent contract. Okay, now see this sentence. Tell me whether it is true or false. Okay, the contract of insurance is not fully covered under the contract of indemnity. Contract of insurance is not fully covered under the contract of indemnity. True or false? True or false? Answer is absolutely true. Totally true. So like indemnity definition covers only the loss caused due to conduct of promisor or any other person, but it does not cover any loss that is caused due to natural calamities or act of God. But based on judicial decisions, we also include such kind of contract, such kind of so basically because of judicial decisions, such kind of insurances are also valid, but as such they are not specified in the definition of indemnity. Okay, I hope this is very, very, very clear. ठीक है? If you've not written this, just write down. I'll wait for a few seconds and then we will go to the rights of the party. Okay, now let us continue. Rights of indemnity holder. Now what are all the things that the indemnified can recover from the indemnifier? First and foremost, whatever loss is caused to the indemnified, he can recover that from indemnifier. Okay. Now let us consider one example. Let's say for example, I am making some artificial jewelry. Okay. Now I make this jewelry and I sell it to my customers. Fine. What I have done is I have taken an insurance for this jewelry that I have made. Not only for that good, but if any loss is caused to any other person because of this jewelry, they will claim that loss from me. So instead of claiming it from me, I have basically taken an insurance for that as well. So if anyone claims any loss that is caused to them because of that jewelry from me, my insurance company will compensate me with that. Okay. Now consider this example. Okay. I have basically, me seller, I have sold that jewelry to a customer. Okay, I will call this as buyer. Fine. I have taken a contract of indemnity with an insurance company. Fine. Now I sold this jewelry, say worth 5,000 rupees to this buyer. Okay. Now if suppose pehle to, if this jewelry only I have made and something happens to the jewelry, act of God ho gaya or theft agar ho gaya and 5,000 rupees loss has caused to me, insurance company will compensate that to me. So that is the actual loss that is caused to me, the damage that is caused to me which I can recover from the insurance company. Okay. Now this customer, when she purchased the jewelry worth 5,000 rupees, she wore those earrings and she wore that necklace. Okay. She wore it for a few hours, and after that she developed an allergy on her ears and on her neck. So next day I got a love letter at home. I see what that letter is, and oh my god, she has filed a suit on me for recovering 10 lakh rupees. Okay. She says इतना ज़्यादा damage हुआ है उसके skin को, 10 lakh rupees is what she wants me to pay. That love letter I give to the insurance company and I tell them, ये लो, pay करो उसको. So they tell me, what is this 10 lakh rupees? Unreasonably high amount. Do one thing. She is asking you to pay this 10 lakh rupees. So say for example, she has filed a suit on me to recover 10 lakh rupees. Insurance company tells you defend this suit. Now for defending a suit, I am going to incur some expense. First and foremost, major expense will be lawyer charges. Correct? Then court fees. Court also charges fees for other hearings. Okay. Then whatever documents, the affidavits or any other documents with legal validities that you have to make, you also are required to stamp those documents. So documentation requires money. Correct? Not only stamping, but it has to be made on a bond paper. The people making the document also will charge some money. So basically a lot of money is involved if you are filing a suit or defending a suit. है ना? So lawyer charges, court fees, documentation or any other expense that I incur as a part of cost of suit, also I can recover from the insurance company because three conditions are satisfied. First and foremost condition, the insurance company indemnifier asked me to defend this suit. Correct? Secondly, whatever orders they gave to me, I have complied with those orders. I have not contravened any orders. They asked me to hire a lawyer to file this suit, to defend this suit. I am doing exactly that. Correct? And if suppose I had not taken this contract of insurance, if the customer would have filed a suit on me for 10 lakh rupees, do you think, ye lo, immediate 10 lakh rupees, do you think I would have given that entire 10 lakhs? No, I definitely would have fought that suit back. Correct? Now just because I have, this is covered under insurance, am I going to see for the most expensive lawyer? Now lawyers can charge extremely bomb amounts. Their expense can go up to even 15 lakhs, 20 lakhs per day. Am I going to hire a lawyer like that? Definitely not. 10 lakhs ka to case hai. I will hire a lawyer who charges basic, maybe nominal or reasonable fees. Correct? Now even if this contract of insurance would not have been there, I would still have hired the lawyer and I would have searched for a reasonable lawyer and hired the lawyer. So basically I have acted prudent in this case, as if, or even if the contract of insurance was not present. है ना? So if these three conditions are satisfied, the indemnity holder can recover the cost of suit from the indemnifier. What are those three conditions? Firstly, the indemnified has told the indemnifier to defend or to bring a suit. Okay? Indemnifier has told the indemnified to bring or defend the suit. Okay? Second condition, the indemnified has not contravened any orders of the indemnifier. Okay? And third condition, the indemnifier has acted prudent, like he would have acted in case the contract of insurance was not present. Is it clear? So see this, first that the indemnity holder can recover is the damage, the whatever losses caused to him. Second is right to recover the cost of suit. The indemnity holder has a right to recover all the cost which he is compelled to pay in bringing or in defending such a suit. So every cost that he will pay because of filing the suit or recovering the defending the suit, he can recover. But the conditions to be satisfied are the indemnifier authorized him to bring or to defend the suit, the indemnity holder did not contravene the orders of the indemnifier, and the indemnity holder acted as if it would have been prudent for him to act in the absence of any contract of indemnity. So I have not hired an unreasonably high charging lawyer, I have hired a lawyer who takes reasonable fees. Just because ये compensate होने वाला है does not mean that I spend as and how I like it. Okay? Now if suppose instead of going to the court, the indemnifier, he tells me that instead of going to the court, as you are going to incur a lot of expense, why not you settle with the customer? Okay, so I call the customer and I tell the customer that you had demanded 10 lakh rupees from me, right? 10 lakh rupees is very high, can you reduce it? The customer says, okay, I will reduce it and we will fix 9 lakh rupees. So I call the insurance company and I tell them, 9 lakh rupees is what you have to pay. Now they tell me that 9 lakh rupees is very high. Why don't you talk to them and settle this for 5 lakh rupees? So I call the customer again and I request them, or I talk to them, and we settle this for 5 lakh rupees. Okay. Now this 5 lakh that I have to pay, this 5 lakh also I can recover from the insurance company. So the indemnifier will be bound to pay this 5 lakh rupees as well, because again 3 conditions are satisfied. The first condition is that he authorized me to compromise, correct? The second condition is that I did not contravene any orders that he said. So whatever he told was what I have followed. He told me 9 lakh is too high, maybe try for 5 lakh. So that is what I had tried. And third, the indemnity holder acted as if it would have been prudent for him to act in the absence of any contract of indemnity. So even if this contract of indemnity was not present, if the customer would have told, let us settle for 9 lakhs, would I have given off the 9 lakhs? No, definitely I would have tried to lower this, correct? And definitely I would not have incurred any other unnecessary expense, okay? So because these conditions are satisfied, I, indemnity holder, has got a right to recover any sum that is paid by me by way of compromise. Okay? And the last right to sue for specific performance. Specific performance is what? Specific performance is exactly performing what you have promised. So if the goods do not have any other substitutes, if the goods, if the damages as such are not adequate, then the court can grant specific performance, correct? So in case of a contract of indemnity also, if the liability has, indemnifier has incurred an absolute liability and the indemnity holder goes to the court asking for a specific performance, then the indemnifier will have to perform this contract. Okay, so this is basically like a normal right, nothing extra or additional kind of a right, but anyway it is given, we'll also read it as it is. Okay, so the 4 rights of indemnity holder are right to recover damages, right to recover cost of suit, right to recover sums paid as compromise, and right to sue for a specific performance. Okay, so in the second and third right to recover cost of suit and right to recover sums paid as a compromise, the conditions that to be satisfied are the indemnifier authorized him to bring or defend a suit or to compromise, the indemnity holder did not contravene the orders of the indemnifier, and the indemnity holder acted as if it would have been prudent for him to act in case this contract of indemnity was not present. Is it okay? Now this was, or this is it about contract of indemnity. Okay, now if you see, the rights of indemnifier are not present, but they are similar to the rights of surety, which we are going to discuss in contract of guarantee. Okay, So Act doesn't specify the rights of indemnifier, but they are similar to the rights of surety. Okay. So let us quickly revise what we have seen in contract of indemnity. So contract of indemnity means making good the loss or compensating the other party for the loss that is caused. The two parties in contract of indemnity are the indemnifier and indemnified. Indemnified is also called as the indemnity holder, correct? Is this contract of indemnity also a contract? Yes, since it is also a contract, all the essential elements of a valid contract have to be satisfied, correct? This contract of indemnity can be an express contract or an implied contract. Then the loss to a party has to be certain. Only when the loss is certain, the indemnifier's liability arises. Okay. So again, putting this differently, when does the liability of the indemnifier arise? When the loss of the indemnified becomes certain. If there is no loss caused to the indemnified, then will the indemnifier compensate anything? No. So loss has to be present for compensation to be present by the indemnifier. Okay. Then the reason for the loss can be conduct of the promisor, conduct of any other person, or any act or any event which is not in control of the parties. The four rights of indemnity holder are right to recover damages, right to recover cost of suit, right to recover sums paid in by way of compromise, and right to sue for specific performance. Is this okay? So I'd like to stop today's class over here. In the next session, we will continue from contract of guarantee. Okay. I hope this was very, very, very clear to you. So have a nice day, all of you.